discovery, and so quite a bit of it. And
What does that have to do with what you're asking for out of the the police? Where was it? The police department?
so there's this is the initial testimonies given by the witnesses there in Kerberville. No, all the witnesses all together. Also, basically, that's what it is.
The initial report started. The initial report started in Kirbyville, where the victim lived with her family. When it was determined that the actual offenses were occurred here in Jefferson County, it all got transferred here. All the reports that we know in existence are in discovery, and he's been given a copy of.
Everything you have, he's been given?
Correct, Judge.
All right. Anything else? That's what he's saying.
Well,
What is it that you know that exists that he's not given?
I've looked at what I was given. It is not the same thing that I actually sold.
Say that again. I'm sorry.
I'm saying what I've been given or what I've been disclosed from him as far as the reports or the initial investigation reports is not what I actually read and I've seen previously as far as
give me an example of what I don't follow you.
Okay, I'm speaking about when initially my witness supposedly made this report. They walked into the Kerberville local police station and they gave statements there, written statements signed. The reason I need it, I know it exists because it's inconsistent with what this report show, and that works towards my defense, I believe.
Well, they either exist or they don't, and the state says they've given you everything, and that's all we can do. Anything else? When are we able? When can we specially set this for a trial, folks?
State's ready, Judge.
And then,
You're not ready yet. Is that right?
I mean, I definitely need this to spin and get the chat forum with the chat thread from the adult website where I initially met the witness. That is very.
He's trying to develop
that, John.
He's trying to file a subpoena for that. Whether they turn it over, I don't know, but we can.
He's trying to develop a defense about the age of the person, and I've explained to him that that's not a defense to this offense, Judge.
This whole deal was, I mean, everything matters. I've seen the evidence disclosed to me, and if I'm able to get that chat thread, it would actually shed light to some of the false testimonies given. You know what I mean? It's part of it. Again, it's important.
However you want to accommodate him, Judge, state's ready.
Get that thing, that particular thing done. Let me know when that is accomplished. We'll set the trial.
Your Honor, I have one more thing to say. The written report he was talking about, it's basically SMS texting between me and witnesses and whatnot. I need to see about the authenticity of that message there, because
I don't know.
It's not.
I don't know what you're talking about.
John,
do you know what he's talking about?
It's not reliable.
It's a Cellbrite report from phone data, Judge.
There are messages missing there. I specifically remember. I don't know if it's just been doctored. I don't want to,
Y'all got from the state. You have.
Your Honor, we've had these records back to the time in which he had counsel representing him. We filed those records with the proper notice that we would be using it as business records. There has been no objections to any of that. I provided him the entire written report just to make sure that he's being given the entire amount.
What is it that he doesn't have?
Well, he's
you have-
claiming that there's things that aren't there,
I know-
but
no, that you
they're just
have-
claims.
That you have, that you can give him? What else is there that you have not given?
I've given him everything.
All right, that's, oh, you can shake your head all day long, but you're gonna have to show that he's hiding something because he has more to lose than you do. This
I
man,
understand,
this,
you know, Your Honor,
and you interrupt me. The point is those, professional people have never been accused of wrongdoing. And they say they have submitted to you all that they have in discovery. And you're saying, no, they haven't. You're going to have to prove that there's something that they don't have, because that's the way it works. They've submitted and their law license reputation is at risk. And I've not known them to hide the ball. They provide what they say, and there are severe ramifications if they are misleading. I trust the way they've done things, and we've never caught them misleading people or acting unprofessionally. You say, no, it's not. They say they presented to you, and the way is if it's going to be your burden to figure out what's missing and what exists that hadn't been given to you.
No, the paperwork that I have seen, that has been given, that I was able to review. I mean, it's evident that messages are missing. I don't know if they've been deleted or what.
Okay, during the trial, if that's your strategy, you can bring that up in the trial, and it's up for the jury to decide what's the truth. That's why we have jury trials. They're the ultimate determiner, and we've done this 615 times, a world record in this court, and jurors take care of their business, and that's what we'll do. We'll leave it to them to decide what the facts are. That is all. Thank you.
Judge, I can special set this
Yes.
on October the 26th.
What does everybody say?